guys, welcome to another call. This call we're going to be talking with Jim Eckley of Eckley Law, and we're going to be talking about my favorite topic, and that is LLCs, specifically taking advantage of out-of-state LLCs for maximum leverage and benefit. And before we introduce Jim, I want to throw up a slide, and the next slide that comes up is going to really set the frame and the direction that we're going to go in this call. If we can get the next slide up, the next one, the next one. And as it comes up shortly, there it is. And this is a excerpt from Judge Learned Hand, who actually happens to be the probably, well, in actuality, the most quoted judge that is not a Supreme Court justice, which is a pretty big feat. And I'm going to go ahead and read his quote because I think it's really important and it's going to frame the direction of our conversation today. Change his affairs so that his taxes shall be as low as possible. He is not bound to choose that pattern which best pays the Treasury. In other words, the U.S. government. There is not even a patriotic duty to increase one's taxes. Over and over again, the courts have said that there is nothing sinister in so arranging affairs as to keep taxes as low as possible. Everyone does it, rich and poor people alike, and all do it right, for nobody owes and public duty to pay more than the law demands. And with that, I'm going to introduce tonight's guest, and that is Jim Eckley, and welcome, and thanks for being with us, Jim.
Thank you very much, Mark. I'm glad that you invite me to these sessions. They're always fun, and I always think they are probably cutting edge, since they skirt things all the time that are somewhat controversial or about which there's been a lot of disinformation published. So it always gives us the opportunity to set things right. We're the folks that have been to these venues often enough. We've been to this place. We've been to this rodeo. So I think many times we're a little bit more capable of speaking about it with greater truth and with no real political reason to say it other than it is. So I always like these programs that you put on because that's where it can be told like it is.
Yeah, for sure. And we've talked about some of this stuff before, but we've never actually done a conclusive interview in regards to LLCs. And of course, as we'll conclude this call, we'll talk about the Panama Papers and how this space has actually evolved over time. That being said, let's get right into this and talk about specifically what Judge Learned Hand was talking about. And of course, as you see, and I want people to be empowered by this call, most importantly with respect to their ability to choose. And of course, so why is it that you see various attorneys send out letters to their database? Of course, the attorney happens to be in their own state with respect to this being some sort of fraud that you can't pick. You can't go out of state to form your entity.
Well, it's not only a matter of entities, but in this particular quote that you gave everybody from Judge Learned Hand, it was a case in which the taxpayer had been claimed against by the government for more taxes and had demonstrated that there was two different ways to express his net taxes by virtue of reducing income aggressively by taking deductions that were considered to be aggressive, and that reason they would pay less tax because they claimed more deduction. And it was found that there was good foundation for those to be very aggressive. And as a result, the court found for the party who was the taxpayer and determined that they had taken an aggressive technique, but there was absolutely no duty to take the other step, which would have maximized their taxes and had them pay more. A really good example of that is one of the first cases I had years ago. Been at this 40 years now, but in the first couple of years you get some interesting cases, and they're always ones of first impression because you haven't gone to that rodeo before at that point. But I had one in which there was a large building, and when you depreciate a large building that you're holding for investment or business purposes, you have to establish a salvage value. and then you depreciate the rest. So the question always is, what is the salvage value of my building? And at those days, it was a 15-year write-off. That was on a rapid depreciation schedule where you could write off the building over 15 years. So what would be its depreciated value? And in many cases, people usually use a 20/80. They say, well, 20% seems IRS believes that's sort of a safe harbor. In 15 years, it's going to be worth about 20% of what I paid for it. So the 80% I'll divide by 15 years, and I'll take that much deduction for depreciation every single year that I'm in the building. Now, that was fairly, standard. That's what IRS usually likes to see. These folks said, no, my building's probably going to be worth more like 5%. So that gave 95% of the building's value to write off over 15 years, which gave them a much higher depreciation. Now, I'm not speaking now of the Helvering versus Gregory case. I'm talking about one I did. And so that was aggressive, and IRS actually challenged it, as did the property tax folks challenged that valuation. And I hired an appraiser who came out and said, well, the reason it's at that percentage is because it's at a point in the road that is likely to be enlarged over time, because the public highway department come by about once every 3 or 4 years and made further condemnations and was cutting away at this parcel, making it smaller and smaller until pretty soon the traffic is going to be going right by the windows of the building. So then what was the building going to be worth? I mean, the only thing left was the building, and it's being rattled by trucks passing it during the day. So there was a very good argument for that. And the revenue services and the property tax folks were not buying it. We had to go to hearing, and ultimately the judge bought into that and said, yeah, you're right. That's probably a very realistic depreciation scale. No, it is not the one IRS typically wants to see. No, it's not even one that's offered by the schedules. But it happens to be realistic and well supported. So my taxpayer got that advantage. So that's what I mean by aggressive. It doesn't mean it's illegal. It means that you're taking a position that's outside of a matrix or a general format that the revenue service or whoever your adversary would like to see, and you're having to prove it. And if you can, then you ought to win, and that's not unpatriotic, it's not crooked, it's not dirty pool, it's not lawyers stealing the show and ripping everybody off and, using their mouth instead of their ethics to better off a client. No, there's good value to that, and that's why there's better lawyers than others out here. There's as in all things, there's good ones, bad ones, in between ones that are just here as a hobby, and then ones that are here as a career or a profession, and sometimes even a lifestyle. If you're a good lawyer, you're usually making lawyering a lifestyle. So let's go back to those lawyers that are critical and write essays about going out of state and how there's some question about that, or doing anything that would hinder, delay, or avoid a creditor. Well, if you're going to look, you're going to find out most of those have what I call a creditor's practice. In other words, they're good buddies of the guys that are out to get the guys that are using these techniques lawfully to set themselves up to minimize exposure or maybe even escape exposure and liability matters. And there are issues out there that obviously are high liability. Well, being a realtor, as an example, is a pretty high liability business. Being an accountant, a stockbroker, an attorney, a CPA, do those guys use these techniques to put them in, things like trusts and LLCs and so on, to put their valuable assets and their businesses in? Of course they do. And why are those entities out there? Well, society created them for that very purpose, to limit your exposure, because in that way, you can decide what you want to put at risk and make a business decision that that's what you're going to put at risk, and then go out and engage in business. And capitalism says you don't win every time you pull the trigger. Do remember that stock is really one of those kind of things that says you got a ticket to try to make money, but it doesn't mean you're going to make money with the stock. That company may go upside down and everybody loses money on the stock. Is it illegal? Is it a crime? Is it a scam? Well, I suppose it could be, but in most cases it's not. And they've typically jumped through all the SEC procedures of giving everybody high warning. This company may not work and you may lose money, but you're only going to lose whatever amount you put at stake through that stock. You're not going to lose everything you've ever had or ever will have, or that your heirs and descendants will ever have. So the idea that in capitalism you can limit your exposure is deeply ingrained, and it's the whole concept behind incorporation and the creation of entities. Otherwise, they'd make virtually no sense. So yes, you do have a cadre of attorneys and others who just feel like anything that allows a debtor maybe to limit their exposure or to maybe even eliminate it is somehow just not right. So they'll criticize it. And then my last point. Everybody has the capacity to criticize. I don't think there's one legal principle out there, even ones I espouse, that I couldn't take the other side. I mean, I think that's what people dislike so much about lawyers, and that is they can say on the one hand this, but on the other hand that, and they can seem to argue either side with equal amounts of aggressiveness so that both of them sound credible, and then they say, well, what is the answer? Well, that's the darndest thing about law. The answer is whatever the judge or jury says it is, and that's where you get a hearing by your peers. So is there something wrong with being an advocate and saying, no, I think this is going to work. I think this is where you ought to be. And then having someone else on the other side, maybe representing a creditor, saying, no, by God, I think all of this is a conspiracy. Yeah, I guess they can say that. And then what's going to happen is justice is going to make a decision as to who's right or wrong. But the mere fact that you bank across state lines or start an entity across state lines as somehow engaging in some dark-handed devilry is absolutely absurd. I mean, if that was the case, your own 401k would be involved as a criminal conspiracy because it probably has an administrator that's from out of state, administering a fund that's out of state for a fund that's probably invested in European bonds or Vietnamese certificates of sovereign participation. And it's probably got a bank account in Delaware. So I guess it must be one of the biggest conspiracies known to man. And why does it do all that? It's to protect you and your pension. That's why. And there's good economic reason to do it. So most of these have good economic reasons. It's just a matter of whose ox is being gored.
Well, it's comical that if you think about it, that there's so many banks that have been doing this for years and years and years. Your payment is collected in one location, state. It's underwritten in another state. It's funded in another, and of course the operations are in another state. So if an attorney's telling you that, or a CPA is telling you that you can't form your entity out of state, so they're saying you're not. Apparently, in their eyes, it's not good enough. It's good enough for corporate America, but it's not good enough for you.
That seems to be, that is. But it's also more than that. It may even be a felt class struggle of some kind. Some people think that all rich people ought to die, and they're ready tomorrow to get their M1 carbines out and start lining anybody that has more than $500 up against the wall because they personally only have $50 in their life. So a lot of it has to do with ego and envy and other things. That it just generally isn't true. I mean, I have a Wells Fargo account that I write my checks to a bank in Utah on, and the Wells Fargo bank is right across the street from me. So, I mean, is this a conspiracy? And my check, by the way, is on the Bank of Hawaii, which is where I happen to keep some money because I have a third home over there, and I keep my banking practices there for some of those purposes. I guess I'm just a malefactor if it gets down to that because I'm in 3 different states on one single deal, but the bank is too. So I don't know which one of us is the biggest malefactor in that formula. So yeah, I think those kinds of things have to be couched from the viewpoint of those people and where they're coming from. And yes, there's people on both sides of these things. I'll give you an example. It's horrible to have a person pursuing for a legitimate wrong. Maybe some bread truck ran them over, and they go out to pursue the corporation that owned the bread truck. The driver's long since gone, and he hasn't got 2 nickels to put together anyway. He's just a driver for the bread company, and he's to split. So the only one you have left is the bread company, and they turn around and file bankruptcy. And your client has highly traumatic injuries. They may never really walk again. They may have lost a limb. They may be mentally impaired for the balance of their life and have pain and suffering. And yet this guy with the LLC or the bank the corporation that owns a bread truck gets off because they only had 50 grand in the bank. So that's pretty much about all you're going to get. Now, there is a tremendous frustration there. But that's kind of the way a corporate or a capitalistic society works. And so those are some of the rubs that happen, and there is an issue about that. I agree, and I get it. From the standpoint of the folks that made the bread company and put it up, they put a couple of $100 grand into it, and things didn't go well, and they ended up with only 50 left, and now you're going to clean them out. So they're losing every single nickel of their investment, and they go away with their heads hung low because now they're a pariah in the industry because they went broke. So everybody pays a little bit out of these things. And by the way, In that scenario I just cut, that's really not terribly unrealistic. That's actually after a case. And in that particular case, the party who was the aggrieved party and the injured party wasn't without recompense. They also had their own insurance, and it was a PIP state, meaning that they can get their own personal protection under their own policy. So they ultimately got protected, but under their own insurance policy. So there's always alternative protections. So I see now you've got you're moving the screen around a little bit. You're getting into some other slides here. I'm sure I'm going to be open for another question.
Yeah, we're trying to move this. We're moving this forward into the next topic.
Not a problem.
So one of the topics, and this is sort of a jumbled topic, but we do have real estate investors primarily in terms of the viewership on this call. Real brief, and just picking off a couple of key points. Why does someone, because we do get this question that comes up, LLC versus corp, why would someone want an LLC in lieu of a corporation?
Well, nowadays it's almost the reverse question among the lawyers that do this, and that is, why would someone want an S corporation when they can have an LLC? When LLCs first came about a couple decades ago, they were really experimental because they were an entirely new creature. No one really knew what they were, and some of the states didn't even recognize them. So if your LLC went across state borders for any reason, suddenly it wasn't even an LLC anymore. No one really knew what it was. It might even be an unprotected proprietorship, not even an entity. That's all changed because LLCs have earned their way now, I think, into legal respect. With an S corporation, of course, obviously what you do is you file to become a corporation.
And just to interrupt, when we're talking about corp here, just for place, Mark, we are talking about an S corp because naturally these are small business owners that are less than 75 individuals in membership. So
right. Well, and S corps also have some defects. One of which, and I'll try to abbreviate because I know we have a lot of topics to cover. But corporations themselves, do keep in mind, are high management vehicles. Yeah. They're one of the higher ones as far as doing corporate minutes and meetings and making sure that everything is documented. There's a very high level there. Plus, there's a limitation on who can own the stock. You may want your trust to own the stock, or you might want your LLC to own the stock. But in S corporations, the stock can only be owned by a natural person, which for tax planners and lawyers and so on, it really limits quite a bit of what you can do with those stock to move it around and make even more sense with that S corporation. The S corporation also doesn't necessarily protect you from liability, like a lot of people think, but then again, there are some theories in liability that go beyond all of these entities and can still generate liability. Let me give you the example. Let's go back to my bread truck. If it went through the red light and struck my client, and the guy that was driving it also happened to be one of the vice presidents of the company, then, and a member and owns stock in the company, the S corporation, then not only can I claim against the S corporation that owns the truck, but I could claim against him personally because his was the hand that was on the wheel. He's jointly and severally liable in many states, and in other states he's contributorily liable, or there's a balance between the fault rating. Maybe he was 70% at fault and the corporation was 30% at fault, but there can still be fault that penetrates the corporation because of the actor who did it. And corporations cannot engage in fraud, they cannot engage in illegal activity. That will penetrate through and reach the people on the other end. So there's no magic particularly about an S corporation, and what it really does is it tends to give a person a false feeling of security, and it also is highly intensive in keeping it up daily in its administration and limited in where its equity can be go and be held by. In an LLC, there is no such limitation. And an LLC can elect to be taxed as though it was a corporation or an S corporation if it wants to. So LLCs can be taxed based upon the option that you file at the time you make your tax selection and form your company and get your EIN. You can form it as a proprietorship. In other words, though you have an LLC, it still creates a limit against liability for the overall entity. You can elect to be personally taxed on its net income as though it was a proprietorship, like you just set up a lawnmower shop down in the corner and every nickel that comes in is income and every nickel that goes out is an expense. Or you can elect to be taxed as a partnership. Partnership typically needs 2 or more members, so you can elect to have it all pass through the company and be taxed to you at your individual rates as though it was a partnership. And then the last election, of course, is that you can elect to be taxed at almost an entity level. There's a couple more pieces of paper that have to be done, but you can be taxed like you were a C corporation, which means you're taxed both at the LLC level and below. A lot of the oil partnerships and gas partnerships will actually do things like that, triggering that taxation. The problem is most people don't want to have double tax, and a C corporation generates that possibility. So S corporations are fragile and hard to run. C corporations are also fragile, hard to run, but they also can result in double taxation. An LLC has the ability to have the same protection against outside liability, but at the same time to be taxed on a pass-through basis that goes down to the personal level and pays taxes only at the personal level. So it's got the best of both worlds. It can be held by anybody. It can be held by a trust, a corporation, an internal one, an external one, a foreign one, a domestic one. None of these things sever the LLC treatment like it can with a corporation. And up until recently, LLCs could have a foreign member or have foreign funds and didn't have to independently file notice of those things with the federal government. Now, that is slightly changing, and the reason is that a lot of terrorist funds have felt to be coming in, or funds that have illegal sources. So the government, as part of its anti-immigration policy, which there's nothing better to call it, it certainly seems recently that it's an anti-immigration policy, is not just worried about the immigration of bodies, but it's worried about the immigration of money. So now it's looking at these pass-through entities a little bit more carefully and asking at least that informational filings be made to show that there is a foreign source of funds or a foreign person involved. But other than that, and that's with all of them, every one of the entities, but with the LLC, it really is the winner because it is so malleable and can be used in so many ways.
Gotcha. Perfect. So moving along, we're going to move into the third of our 4 topics that we'll be talking about tonight, and that is based on security and privacy issues. Specifically, a couple items I want to get into here is when we talk about the corporate veil as sort of a blanket term for the whole entire reason above and beyond taxes and expenses to use an LLC. Can we talk about this idea and this concept that obviously has been in our corporate law system for a long time, and that is of the corporate veil? And then, of course, I want to talk about what we've seen as a more recent trend of an LLC potentially replacing a trust.
Yeah, well, let's start with the last one first, because it's the bigger trend, I think.
Yeah.
You said along the lines, which I think is entirely accurate, that LLCs are starting to replace trusts per se. And let me tell you why that's true. Since 2006, September of 2006, which was considered the beginning of the end, when we had that horrendous, they're saying recession, I would call it the Second Great Depression, that lasted until now the official numbers are September 2011, although I kind of have my doubts. I suspect it's still lasting, and I don't believe a lot of that is behind us, and for most of the middle class and the lower classes, that isn't behind us yet. But when that big calamity happened, there was a feeling then that a lot of people ran and put money into their family trust, among other things. And trusts were really the big deal back then. That was sort of the soup du jour of the day for purposes of tax planning. And almost everybody had a family trust. And even to this very day, if you look at the records of buying and selling in land, you're going to see one family trust selling to the other family trust. Well, the impression was that family trusts somehow had the immunity of a trust. In other words, whatever was inside of it was immune from whatever was outside of it. So if you had some kind of trouble outside, like you couldn't pay your credit card debt, no one could penetrate your trust to get to your residential property that was inside your trust with that residential debt. Well, what happened was that when the calamity happened, all the banks and all the creditors of the world got together and started attacking trusts. That was their first attack because there were more of them out there. Virtually everybody has a family trust, or at least did. So these were being hauled up before the court again and again and again. California is a really good example. Had the most trusts and had the most court activity on it probably than any other state than Texas and New York. And so the trusts were being hammered on by some of the best lawyers in town, representing some of the biggest banks that had the most money to hammer on them, because they needed to crack them open and get the money that they weren't getting from these borrowers through other sources in the traditional sources. And one by one, these trusts were busted, and new principles were created about trusts that were very difficult for most of them to keep up with. In fact, most living trusts to this very day are totally penetrable. And let me tell you why. Because one of the elements that the court came up with to determine whether they were penetrable is they said if the borrower, or in this case the debtor or the liable party, can reach any asset of that trust or can supervise the activities of the trustee of that trust, saying such things as pay me or pay that person, then the creditor can follow the power of that party. So if someone owes money and they're not paying it, and they have a trust and they have the right to direct when money comes out and to whom, then the creditor can execute and levy on that right and use that right themselves to gain virtually every access that the debtor himself could have, and go out then and direct the trustee to pay them, among others. So when that principle came down, it was almost the death knell for a lot of these trusts the way they were written. So now it comes down to how much control do you have over the trust? And if you have very much control, automatically you are then deemed to have made it accessible. And that's pretty much the law of most states. Now, they have come up with, of course, the lawyers are always trying to be inventive. They've come up with what now is called the Domestic Asset Protection Trust, the DASP. The problem is that not a lot of states recognize these yet. They still say, well, if you have any control whatsoever, then we're going to penetrate it. Some states have adopted those type of trusts as a state law and approved them and limited them by state statute. Now, when the state has spoken on a trust and created a statute, the courts can't tear it apart. That means it's sacrosanct. It means the public itself has decided that's the way it ought to be, and the judges who are not to make law are going to have to obey the law and can't penetrate them. South Dakota, who I guess we're going to talk about here in a minute, is one of those cases. They've created a safe harbor trust, and that trust is almost impenetrable. And in fact, the better thinking right now is that you should have your LLC owned by your DASP, but I will go into that later if we get to it. So trusts then became sort of an anathema, and in their place, people were looking around, folks like me who try to help those people that want to limit their exposure out there in whatever business they're doing or protect assets that they've spent a life earning. We try to think of new ideas as old ones fall apart. We read what the court says, and it's giving us leadership. It's saying, don't do it this way, do it that way. So we go, okay, then that's what we'll do. The LLCs were faring very, very well. They were the ones that kept surviving. And the reason is that, yes, in an LLC you may have a lot of control, but that control doesn't equal accessibility by the creditor. For instance, if we have an LLC and I'm a 51% member, which means obviously I'm going to call most of the shots, just because I'm a 51% member doesn't mean now all the assets inside that LLC, which could be my car wash company business or my motel or something, now becomes accessible to outside creditors who are seeking to levy or attach me, or even a domestic relations matter where I have an ex-spouse or something chasing me. It doesn't mean that they're automatically eligible to be executed by virtue of that control, which was the case on trusts. The reason? State law has said otherwise, and a few states have made themselves a haven by making a state law that utterly protects that membership from being levied, seized, and sold, or from that membership alone being a channel through which an irate creditor and ex-spouse can channel themselves into that LLC and take what's in it merely because of that control. That was the big change. It was created by statute, and it completely avoids all that old claptrap and all the bad law about trusts, because there's a lot of bad law on the book, and bad meaning it doesn't help you much. And the LLC was a clean slate, and legislatures in many states wrote on that slate however they wanted to, that it was either going to be penetrable or not. And in that case, if you're in a state where it's not penetrable, that's the law that's going to be followed by any judge, and that means that you're safe. And those states are really still few, but they are there as this movement spreads across the country. So that's when LLCs became popular, and then that's when everybody awakened to the power of these LLCs, a whole new critter, and that the slate was blank and we could write anything we wanted on it, and that's what we've been doing.
So then, real quick, I'm not going to say that we've gotten this question before, but it does come up indirectly. I'll just leave it at that. With respect to privacy and protections, is everyone protected? at all times under every circumstance?
No, that's one of those questions about anything that's 100% yes or 100% no is always wrong. No, there's no such thing as a free banana. It just doesn't work that way.
What are the two general categories?
Well, here's what I would say. You ask about privacy. Privacy and confidentiality. A lot of those things have probably gone out the window with the advent of the web age. There's e-sleuths all over the place, and there's a practice by almost all of these resources where data and information is to dump them all into the internet, so that even in spite of yourself and attempting to keep yourself enshrouded with the privacy that you have every right to have. In fact, there is a constitutional right to privacy that's already been decided by the Supreme Court. You're not.
You know how many credit bureaus now we're up to?
Credit bureaus? No, I don't.
For data organizations that are collecting and selling our information, we're up to 44 now.
Does that count also the Russian mafia and the black web, who apparently is selling quite a bit of them after that recent disruption with one of our big credit rating agencies? Well, and we're going to see more of that. I don't think there's any encryption or any way to vault something electronically that cannot be undone. But also, it's an attitude that the internet First Amendment concept that anything is fair game on the internet, that itself has probably prompted more data being dumped in there than anyone ever even thought of. So that we used to think that the crime and the crisis of modern society was going to be that Big Brother was going to be the government and have cameras looking at us and recording everything we do. It turned out that Big Brother is our next door neighbor with cameras on us and recording everything we do. No one ever thought that was going to come about, but that seems to be it. And I want to go one step better on that issue a little bit, because that'll going to bring us into the Panama Papers and the new Paradise Papers scams that are out there. Terrible situation for those who have been suddenly had all their financial wherewithal published all over the net. But the point is, if you think that the internet was that you can publish and say anything you want on the net, internet anarchy, and that's the definition of the First Amendment. The Supreme Court has never defined the First Amendment that way. The First Amendment protections to say pretty much anything you want, or anything political, like I don't like the president, or I think the vice president's an idiot, or my congressman, is a terrible guy. That gave you the right to go ahead and say things like that with relative impunity, because they've already put themselves in the public eye, and that has courted whatever you may have as an opinion, and that's politics. But you don't have the right to invade personal sanctity of people that haven't put themselves in a spotlight like that. So when somebody finds themselves peering, in a sense, through people's bedroom windows, they've gone too far. Privacy is still the realm, and unless I've done something to put myself in a public spotlight, like I go out and run naked down the street or something, then there is no inherent right to say anything you want about me and start checking me out. And that is where the First Amendment has always been misconstrued on the web. Plus, if that's true, if you can say anything you want to with impunity on the web, which the Communication Decency Act, Section 205, seems to say that you can, which I believe is going to disappear pretty soon, then all the fake news is also legal. And this is what scared this country, is to find out that under Section 205, the same thing that I can go on the net and rave horribly, maybe even defame somebody and have some impunity on it, is the same thing that also allows Russians to publish false news. And we all believe it, because after all, they have a right to say anything they want to, right? Anybody on the net gets to say anything they want to. And that now they found out can actually overthrow governments. Now it's got everybody's attention. Plus the widespread use of the internet for prostitution and money laundering from totally illegal sources, gun running and terrorism. Now, I think there's a sort of a rethinking of the net and having all that data on there as to whether that's a legitimate use of the net and hasn't actually exposed us to far worse. So the balance is to go back to some sense of privacy and vetting what goes out on the net. I think we're going to see substantial changes to that. Now, why do I even bring that up, other than it's a personal thought of my own, and I think it's a trend? I bring it up because most of the lack of privacy on the net is not created by any errors or deficiencies in the way LLCs and corporations and entities are supposed to work. There is supposed to be a degree of confidentiality in the very fact that all the internal operations of your LLC or your corporation art out on the web is part of what you've come to expect as your right. For instance, they're not publishing your balance sheet for your car repair company out there on the web yet, but there's people that think that if they can get their hands on it, they have every reason to publish it. And the question might be, why? But that is something that we've approximated. We've gotten close to that. So now, even if you have purloined documents, you can publish them. And most of the governments and the state governments are going along with this thing about it. If it's information, it has a right to be on the web and the whole world to know. So they're taking LLC members and putting them out there, and everything they file with the state, they're publishing that. And some of them are selling access to it. Some of them are just making it free. There's going to be a point where some real tragedies are going to occur. Some really have already because of that. And I expect that to contract. But in the meantime, there are some states, however, who have tried to guard your privacy a little bit more when you're in one of these entities. And we're going to talk about some of those today, but you've talked about Nevada.
Literally right about now.
Yeah. I mean, that's right. So you're saying, are there some states out there that do it? Well, yeah, there's ones that'll protect it. South Dakota, Delaware, Nevada, Wyoming. These folks make access to these documents much more difficult. For one thing, they don't automatically publish them in the open website like a lot of states do. California publishes everything. Now, of course, California sells that information, but if you want to find out everything about somebody, it's a pretty easy trip in California. But if you're going to have your issues in these states, now remember, what if you decide to set up an LLC in Wyoming, even though you're in California? Can you do that? Yes, of course you can. We can do business between the several states. That was the whole idea why we call it the United States. That's why we have a constitution. At one time, each state printed its own money, and the money from one state wasn't good in the next state. That's all been changed by the full faith and credit clause of the United States Constitution that says we all have the right to do business in every state as long as we jump through its own hurdles. And that isn't illegal, isn't bad, and it's not a matter that needs a public expose.
Does the federal government care do they care for businesses in Nevada or Florida?
No, they don't. Absolutely not. As long as you follow the rules, nobody cares. And that's all they have is rules. And most of these rules are set to stop crime. In other words, they don't want you taking the money just robbed from the local bank and using entities to hide it. So you're going to find things that are related to law enforcement. And the other one, which is more dear to the hearts of government, is to collect taxes. So if you're declaring whatever revenue you make in a lawful way and you're paying taxes on it, and you could even be doing things that make your revenue less, going back to learned hand statement again, so that you don't pay as much taxes on it, then the government is not going to bother you. Oh, by the way, that's another statistic that I thought I would come up with here, just to point out. There is also an audit level. It turns out that the revenue services tend to audit corporations like 3% of the corporations every year. On LLCs, less than 1%. It's amazing. I don't know why that selection has been made.
Wow.
Maybe it's because, so this thing about if you become an LLC in Nevada, suddenly you've just courted the revenue scrutiny. That just isn't true, as long as you follow the rules. So there is nothing wrong with that. In fact, you would highly recommend it. I think it's malpractice, for instance, as a lawyer, if I don't try to take steps to protect my client in lawful ways by maybe dividing their business up and putting it in several different states. And some people do business across state lines. If I'm an interstate trucking company, I'm probably going to have to be licensed and have a cap card in at least 12 to 15 states. And I'm going to have plates that, with allocations between maybe 3 or 4 states. So it's not unusual. I'm just going to have to pay my tab as I do it. And I'm probably derelict if I don't do that with my client, because then they'd be operating an illegal trucking operation. So you got it. This is just pro forma. It's just what you do. And now to talk about taxes. Some states are a little bit better on the taxes than others. Like, for instance, if I decided tomorrow to go live in Nevada or Washington, it happens to be one that has no personal income tax. Have I committed a crime? Why did Washington do that? Why did they make a law that says, come here, live here, spend your money here? And as a reward for that, we just won't charge any state taxes. Now we're going to charge you some property taxes and some sales taxes because we're based on consumption rather than on ownership. But that's how our thinking is. So come on. Well, that was to attract you there. It was to bring you there. It was for good purposes, and it's not for bad ones. Unless you think that the government starting to war with each other about wanting to get residents that have money to come to them is bad. I don't think it is. The governments right now in this country are running their own tax havens. The reason these states that we just mentioned have made it more favorable to come there to be a company, more favorable to put your capital there, and in some cases more favorable to live there, is because they're at war with all the other states at a time of a tough economy to get you to come and dump all your money into their market. They want it. It's worth it. It's a loss leader to get you to do that. So all you're doing is saying, okay, I'll take you up on that deal. And you'll incorporate or LLC in a given jurisdiction for all those good tax or liability limitation purposes that they themselves created. They weren't fools. It wasn't by accident. It was by design.
Yeah. Yeah. So let's talk about, obviously, the Panama Papers, the series of two. I think it was in USA Today. I can't even remember. It seems like it's been so long, but it really was, not just short of 2 years now when they came out. It sort of rocked the space. And one of the list of questions we actually had was in regards to Nevada and whether it's still a good state to be in. And of course, as we know, South Dakota is sort of changing as well. So let's talk about I love, as you know, Wyoming. Let's talk about the various states that, and the general basic top reason that you would want to have a Wyoming entity or a South Dakota entity or even a Delaware entity. And of course, Nevada is still sort of in the space, but let's talk about the Panama Papers and the effect that it's had on the various states that advantaged within an out-of-state entity.
Well, as in all things, the press controls what interests people rather than people controlling what the press should be covering. So the press is always looking for something that's loud, extraordinary, and moves them up to the top of your click chart. And that's what sells. That's what sells newspapers, as they used to say, and it's certainly what sells advertising. So now, again, with a feeling of the press that everybody ought to be outed, there's an attitude. Our press is sort of a liberal. I agree with Trump in that regard. It's a sort of a liberal, sort of left-leaning sort of an estate. Essentially, it wants to out people. And it sells papers by doing that, although it always says, well, no, this is in the interest of everybody wanting to know. Well, just because everybody wants to know what color underpants I wear, I don't think the press has the right to go snooping in my laundry to find that out. I mean, I think there's certain things that are personal and ought to be protected, and especially in a capitalist economy, if everybody feels like they're going to be outed and have all their corporate minutes of their internal thinking, like Amazon, when Bezos gets in there and makes his statement in front of the closed meeting of the board of directors, I think he does it with the expectation that nobody there is taking notes and is going to turn it over and have it published in the front page of the newspaper or as the #1 CNN program the next night. Or at least everybody hopes that, because if there was no confidentiality at all, then it would destroy all of these systems, which are there for purposes of protection and privacy. Well, the Panama Papers was a case in which it wasn't the states that suddenly released the information. It was a case of a law firm that was in Panama that actually, Fosac Manseco, which was actually a fairly popular law practice, and a lot of people used them. They had prime ministers, they had princes and kings and queens, and they had Russian folks in there, and they had Ukrainians and Chinese and American and so on, that were wealthy people who, for one reason or another, have decided that they want to offshore money. Now, some for tax purposes. Panama actually has a wonderful tax program that will save you a lot of money, and it's a very stable country because the dollars and the Panamanian dollar and the U.S. dollar are interchangeable, and their treasury is based upon a holding of U.S. dollars. So it's a very stable economy. It's very dollar-oriented. It really mates well with the United States. So a lot of people were there legitimately asking these attorneys to place them in numerous states and in numerous jurisdictions to give them the best protection for privacy, for liability, which in itself is a privacy protection, and also for tax purposes, and that firm did that. It made a lot of money doing it, and it ought to. It was its own area of expertise. When these papers were published, someone purloined them, probably an employee, no one really knows. They went in and took all the records of the internal records of these people when they were talking to their lawyer and having confidential conversations with them about taxes and about their own legal ambitions and what they really wanted to accomplish. And the lawyer was giving them personal advice. All of these notes were published in the web. And so everyone could read everything about all your legal affairs. Imagine yourself in something like that. And now they're reading everything. Well, you'd be terrorized, and you'd certainly be mad as hell. And those people certainly were. But the press says, look, we're the press. Everybody has a right to know First Amendment. That actually isn't true. They're getting sued over that. And they deserve to be. Because a lot of these people are just, they only had one sin. They were wealthy. Is that a sin? I mean, if wealth is a sin, then you're in the wrong country. You really got to go someplace else. The idea in this country is to be able to, with the sweat of your brow and the wisdom that you're able to bring and the break in your back, to be able to get ahead and make some money, as long as you make it legally. And most of these people were people who had made it legally. There was even some big oil companies in there, some banks in there. It's very, for good tax reasons, jurisdictional reasons. And so they really didn't do anything antisocial to deserve being, quote, outed, unquote. But now everybody thinks that you can out anybody on anything and that it's fair play. It's not really. So a lot of people were harmed by that, and a lot of people are taking action about that. But since there are things like WikiLeaks and other places where almost no sin isn't forgiven by the right to, quote, unquote, First Amendment, they keep calling it First Amendment transparency. Transparency was never the right to go in and steal papers and interfere with the attorney-client relationship. Do remember that those are sacrosanct and protected by the U.S. Constitution. So no one was doing anybody any favors there. Well, and so part of the Panama Papers showed that a lot of the entities that were set up were in Nevada, Wyoming. Yes, they went to those states you and I have been talking about that had very, very favorable laws. And so then there was a lot of public pressure on those states and the Congress, the legislature of those states, and those who were decision makers to do something about it and maybe make those more transparent, because after all, rich people were putting money there, which, by the way, was the entire objective of the whole state statute in the first place, is so rich people would put their money in that state as opposed to some other. Now, it hasn't got much traction yet because of that very simple principle that rich people have the right to be rich. If they didn't steal it by gun running or terroristic activities, well, then they have the right to be rich. And that's something the world's supposed to protect. Certainly the economic world is supposed to protect, as opposed to the having just complete anarchy, financial anarchy, which is the end of the planet. That's not what we want to have. So there has been some movements in those states now for a little bit more disclosure about what's happening and where the money's coming from and why. Because there was in there probably some people that weren't very nice. Some people like Nigerian, generalissimos who had ill-gotten gains that also were doing business there. But a lot of lawyers that do criminal practices, and of course the word criminal practice, maybe every practice is a criminal practice in a sense, remember that if you don't have some place to go and get criminal representation, that would be pretty much against the Constitution, against why we came to this country. But one more, a lot of principled people that come in can actually be guilty. And you never ask them if they're guilty. You ask them what the facts are that mitigates them being guilty, and those are the ones you try. But what if they're guilty? Does that mean that the law firm should become now a whistleblower that goes immediately to the prosecutor and says, hey, a guilty one just came in yesterday, come on down with the cuffs, take them away? No. Law firms are to protect you and cover and try to find the best route with what reality has dealt you to maybe get you a little softer landing. And that's what lawyers are there for, and it's a darn good thing they are. Without them, there would be we would be a little more miserable than we actually think. So these states are having the pressure. So far, they're resisting. Now, Nevada has created a new sort of a form where you're going to declare after a certain large amount of money that passes through your company, you may have to just alert it in an annual report about how much has gone through. And there are some indication in some of these states that you have to fill out a declaration that says the sums that and the activity I'm conducting here is lawful, and I don't have any problem with that. I mean, after all, it's supposed to be lawful anyway without it. So some things are coming down, but the biggest pressure has been so far on anti-immigration. And so now you have the federal government creating some rules, which again are against immigrants. I hate to say it, but it's true. That are not only against their person coming here, like what's happening with the immigration rules on the SB1s and things, but also, or the EB1s, for the special immigration rules, allow somebody who has a talent that we don't have here to be immigrating here and be used lawfully to be put at the front of the line. Those are worthwhile things. But also, they're also retaliating against their money. So now there is a federal rule that got passed down in May that will go into effect as of January 1st. And the form I'm talking about here is IRS Form 5472. I had to look at my notes on that because it's a relatively new form that says that even LLCs in those states we were talking about, all of them.
Oh, you're talking about the foreign disclosure?
Yes, are going to have to disclose a foreign member or foreign money going into it. Now that's different, and all the states are going to have to observe that, and those states are probably going to feel that because sometimes there have been foreign monies and foreign members that have gone to those 4 states because they have been so light on that kind of disclosure. But now it's a federal law. The state isn't going to require them to do that, but the federal law will. Now there's some exceptions to that, and a good lawyer will tell you what they are, but that's not a subject for today. So yeah, there have been some changes, and it's been as effect of the public attitude these days about outing everybody and about how nothing is safe from being peered at on the internet, and the idea that rich people are bad per se, just bad, which is a scary thought because that's what they thought in Russia, in 1917 when they just killed everybody, and that's what they thought in France, during the great upheaval there in the 1700s when they just killed everybody off with their heads, it was all about if you have money, you're evil. That sounds like a lot of poor people talking to me. And the bad part about it is the poor people stole the money too, on top of beheading the guy who had it. It's a scary sort of a mood of the public, and I don't know where it's going to go. But my guess is, at least as to the money, following the money and following people that are of foreign extraction or that the money is of foreign extraction, is going to become a bigger issue clear across the country, not just in those states. We're going to see more and hear more about that.
Right. So, in closing up, before we move into the questions, and we already actually sort of asked one question. I'm getting some feedback here. So in closing this up, what, do you prefer, I know this is probably a question you wouldn't like to answer, but do you prefer one state over others? We sort of identified 4 states that should be considered. And of course, guys, you did see the legal disclosure that we put up that, and before I let Jim answer this question, this conversation is for educational purposes only. No legal counsel should be considered by listening to this, and clearly the information here is up to date, and that was really the purpose of putting this out there. But that being said, Jim, what would you say? One of the questions that we had was because of what's happened over the last couple of years, they're maybe not, they are maybe not necessarily, and this actually we had 2 questions on this. They're sort of leery on Nevada. What would you say to that? They're basically asking if there's a better choice from amongst the 4 that we loosely have outlined.
Well, I think it's a good question because it's almost the bottom line question. And probably the better answer is to say, do remember the law is fluid. Every one of these legislatures are in session and passing rules virtually every day that can change these things. And one of the things a lawyer that's in this should do, of course, is to stay on top of it. You can't be effective if you're talking yesterday's law today. You have to know what it is. And you're going to see changes because it's a time of enormous flux in the United States politically. So some of probably the biggest choices with the most dangerous failure factors that we've seen since World War II that are going on in this world. Even whole countries are trying to ally themselves against money movement into them or against money movement out of them. China's a really good example. just recently made a rule that not more than 50,000 equivalent in U.S. dollars can leave China. And of course, that's about the time that Bitcoin suddenly went crazy, because the folks that are trying to bail out of China right now, and these are Chinese folks, Chinese billionaires, are using Bitcoins and other subterfuges to move their money out to be able to avoid this official restriction. But that remains to be seen. It's just my point that things change on a daily basis. I would rather take a look at just the ones that we named, because they tend to still be the better ones. If you're going to leave your money in the United States, then there's still value in the four that we talked about, but my favorite right now would be South Dakota. Now, it's been Nevada in the past because Nevada had some pretty good rules, but what happened is the rules haven't changed so much as everybody has flocked to Nevada. And now, just saying I have a Nevada corporation makes eyebrows raise, or a Nevada LLC. People think, well, okay, well, I see, as though that's an issue, and it is only because everybody flocked there. It's one of those things like, if everybody goes there, it's probably good for a while, but then pretty soon, success probably spoils the pool. So it's like these restaurants. You'll have a really nice little restaurant open in town, and pretty soon there's people drifting in and out, and they're starting to say, wow, that's a neat restaurant. You ought to go over there. And you can still get seating and so on. And then pretty soon it's so popular, you have to wait 3.5 hours to even get seating. So everybody goes, well, the hell with that restaurant. We're not going there anymore. And they go someplace else. It's almost becoming that way in some of these states, but not South Dakota. Now, let me tell you why I cap off South Dakota as a good one right now. And you said it earlier, remember, this is not direct legal advice. That can only be happened by engaging a counsel to give you direct advice and talking about your specific circumstances. Right. But if you're going to stay inside the United States, because remember the option is to go outside it, if you're going to stay inside of it, South Dakota, for one central reason. Not only do they have a very good LLC statute that says that mere ownership of a larger and controlling interest and the ability to control the operation of the LLC is not enough to penetrate it and get what's inside of it. It also has recognized the Domestic Asset Protection Trust. And a Domestic Asset Protection Trust is something you'll see in almost all the states, but some states actually state sanction it and say, yeah, that's the one, created by statute, or their state law or the judicial decisions have favored it, and some haven't. Well, South Dakota is one that has favored it. And it says that you can have a domestic asset protection trust in which you actually do direct it. Remember I said before in family trusts and so on in most of the states, 48 of them, that the mere fact that you have control over where assets go is enough to void or at least make accessible to the creditor jurisdiction over whatever you can control. They pass right through you. You're the conduit, and they get to it under this judicial theory of seceding to whatever you have the right to do in order to collect their bill. And South Dakota doesn't follow that rule, and it clearly doesn't follow it.
Jim, just because that what you just said is massive. I mean, that's such a critical point. I want to really hammer that.
Well, and I want to give you one. Well, let me give one last point on that. And the domestic asset trust that's been approved there now says kind of the same thing. So let's say you're the guy that has the money, you put it in the trust for your kids. But during the course of time that it's in trust, you say, well, pay me a little bit of money out of it. Now, if you're in California, that's fatal. That's it. If you have that power, you're toast. So, but in South Dakota, you don't. So now here's the new game plan. You have a South Dakota LLC owned by a South Dakota Domestic Asset Protection Trust. So even if money comes out and comes into the trust, and even if you direct it, that's still not control, inside or outside of that LLC. So that combination is, I think, just plain unbeatable. That'd take forever to try to unknot that and figure out how to penetrate it. And if it's done right, I would tell you right now, unless there was illegal funds in it or something, or avoidable transfer, like the minute before a levy, you move every asset you've got into it, which itself is challengeable, but under other rules, like, called a fraudulent conveyance. When you can see them coming through the front door, when they're pounding down the front door, and about that minute you decide to sell the family farm to Uncle Harry for $1. No, that one isn't going to work. It's got to be before the clouds come in. So that one seems to me, if you don't fall into any of those exceptions, to be pretty darn unbeatable. And South Dakota has been the last on the list. So it's been sort of the unknown factor out there. The only one who's figured this out some time ago, if you'll notice, is Citicorp, who has one of their main installations there for all of the central reasons that I was just talking about. But they knew about this first because even those companies want to cover their assets, you know. They have the right to put them in entities and jurisdictions that best protects them against outside liabilities. So
there's also a little company by the name of Wells Fargo, I believe.
Yeah, Wells Fargo.